It's a new year and a new chance for you to make a fresh start with your compliance. We're going to be bringing you a daily tip, strategy, or idea that you can use to improve your program. Here's your host, Tom Fox, the Compliance Evangelist.
Day 28, pre-acquisition due diligence and mergers in compliance. A company that does not perform adequate due diligence prior to a merger or acquisition may face both legal and business risks. Perhaps most commonly, inadequate due diligence can allow a course of bribery to continue, with all the attendant harms to a business's profitability and reputation, as well as potential civil and criminal liability. Almost compliance practitioners have long been aware of the requirement in the post-acquisition context. The 2012 FCPA Resource Guide focused many compliance practitioners on the need to engage on robust pre-acquisition due diligence as well. The 2020 update made even more clear the need for robust compliance presence in the pre-acquisition phase. It stated, a well-designed compliance program should include comprehensive due diligence of any acquisition targets, as well as a process for timely and orderly integration of the acquired entity into the existing compliance program structures and internal controls. Pre-M&A due diligence, where possible, enables the acquiring company to evaluate more accurately each target's value and negotiate the cost of any corruption or misconduct to be borne by the target. Flawed or incomplete pre- or post-acquisition due diligence and integration can allow misconduct to continue at the target company, causing resulting harm to a business's profitability and reputation and risk civil and criminal liability. This language was followed up with additional questions posed by the DOJ. Under the due diligence process, was the company able to complete pre-acquisition due diligence, and if not, why not? Was the misconduct or risk of misconduct identified during due diligence? Who conducted the risk review for the acquired or merged entities, and how was it done? What is the M&A due diligence for the process generally? Integration in the M&A process. How has the compliance function been integrated into the merger, acquisition, and integration process? Process for connecting due diligence to implementation. What has been the company's process for tracking and remediating misconduct or misconduct risks identified during due diligence process? What has been the company's process for implementing compliance programs and procedures and conducting post-acquisition audits at newly acquired entities? Such an early assessment will inform the transaction evaluation. What is the process on how to plan and execute a strategy to perform pre-acquisition due diligence in the M&A context? I suggest a multi-step approach to plan and execute a strategy to perform pre-acquisition due diligence. Number one, establish a point of contact. Here you need to determine one point of contact which you can liaise through the entire process. Typically, this would be the target CCO if the company is large enough to have a full-time position. Two, collect relevant documents. Attain a detailed list of sales going back 3 to 5 years, broken out by country, and if possible, further broken down by services. All JV contracts, DD on JVs, and other third-party business partners, GTE records of the acquisition target's top sales personnel in high-risk countries, internal audit reports, and other relevant documents. You do not need to investigate de minimis sales amounts, but focus your compliance due diligence inquiry on high-volume sales in high-risk countries. If the acquisition target company uses a sales model of third parties, obtain a complete list. It should be broken out by country and amount of commission paid. Review all of the underlying due diligence on those foreign business representatives, their contracts, and how they were managed after the contracts were executed. Your focus should be on large commission payments in high-risk countries. Next, review the compliance and ethics missions and goals. Here you need to review the code of conduct or other foundational documents a target has to gain some insight into what they publicly espouse. And then three, go into a detailed review of the compliance program. It would include CCO authority and oversight, operational structure of the compliance program, policies, procedures, and code of conduct, training and communication, monitoring and auditing and improvement, reporting and investigation, third-party risk management, and incentives and discipline. Periodically evaluate your M&A review processes, procedures, effectiveness, benchmark against any legal proceedings, opinion releases, or other relevant information. There are multiple red flags which could be raised in this process, which might well warrant further investigation. They include if the target has ineffective compliance program elements in their compliance programs, or if they were in frequent breach of policies and procedures. Obviously, a target which is in financial difficulty would bear close scrutiny. Structurally, if the company did not have a formal ethics and compliance committee at the senior level or board level, this could present negative issues. From the CCO perspective, if the position did not have board or CEO access, or if there were regular reports to the board, it could have an issue for compliance. Conversely, if there were frequently requests to waive policies, management override of controls, or no consistent consequence for management violations, it would present even greater red flags.
We're going to have a quick word from our sponsor, and we'll be right back with today's 3 key takeaways.
So what are today's 3 key takeaways? Number 1, the results of your pre-acquisition due diligence will inform your post-acquisition integration and remediation going forward. Number 2, periodically review your M&A due diligence protocol. And number 3, if red flags appear in the pre-acquisition due diligence, they should be cleared, hopefully before you conclude the sale, but certainly in the integration thereafter.
This is Tom Fox again. Thank you for listening to this episode of 31 Days to a More Effective Compliance Program. I hope you will join me for the entire month of January, where I take a look at some of the significant changes in compliance and FCPA enforcement. 31 Days to a More Effective Compliance Program is a part of the Compliance Podcast Network.
This podcast is a part of the C-Suite Radio Network. For more top business podcasts, visit c-suiteradio.com.